So welcome to our 25th webinar in our webinar series, The New IP Business Models. My name is Rob Stern. I'm one of the two moderators in this program, along with Karen Newsom, who you'll meet in a minute. For those of you who have not seen one of these webinars before, it is part of a series of 75-minute video webinars that we have put together starting in October of 2014. And now, of course, it's March of 2015. And we have been addressing all of the changes, of which there are many, that have occurred in the intellectual property space in the United States and in Europe in particular that have occurred. And we have been going to the best minds in this world of intellectual property, both from the business perspective and the legal perspective. And this webinar series has produced a conference that we will be holding in Silicon Valley on April 23, 2015 in Palo Alto at the Sheraton, where many of the ideas that have been expressed and discussed and debated in these webinar series will be addressed. This will be a real cutting-edge conference that will be the first, we believe, to look at what has really happened in the last 36 months in intellectual property in the United States and Europe, and where things are going. What are the best practices? What are call to actions, if you will, that need to be made? And of course, it's a technology agnostic program that focuses on innovation, how the innovation cycle works, how innovation is funded, how the next wave of innovation will occur in the United States and in Europe. So now we turn to a very important question that we haven't addressed in any webinar series so far, and that is the Seventh Amendment of the United States Constitution, the amendment that provides for a jury trial. And we have two experts here today, Ray Nairo and Steve Susman, who are true knowledgeable trial lawyers when it comes to this very important constitutional right, having each tried many, many cases in civil cases in the federal courts and in the state courts in the United States, including some of the biggest patent cases of all time. So Karen and I will be discussing with them today the Seventh Amendment, why it's important, why it's been under attack from some quarters, where it came from in terms of patent cases, and everything else that relates to the jury trial and the patent case. So, first of all, Ray, thank you for being here. This is the second webinar you've been with us, the first with Kevin Rivette. And we have a copy of Ray's book, Go For It, and you can tell us a little more about that later. But thank you for bringing that with us. And we also have Steve Susman from Susman Godfrey, who is leading a very important project at the New York University Law School in Manhattan, and he'll be telling us about that as it relates to jury trials. So, gentlemen, let's start, if we could. So what is the Seventh Amendment? I mean, why is it in the Constitution of the United States, and why does it really matter?
Well, the Seventh Amendment is in the Constitution of the United States because it is the only right. It's the right that says in suits at common law where more than $20 is at stake, the right to jury trial shall be preserved. And so the right to a jury trial, that's a civil jury trial, but there's a criminal jury trial, grand jury. All of these rights to a jury are mentioned in three of the Bill of Rights. And in the Declaration of Independence, one of the chief causes cited there for breaking away from England was that the king was denying the colonists the right to a jury trial, which allegedly dates back in England to Magna Carta, which we are celebrating the 800th anniversary of this year. And there are many references in Magna Carta to no Englishman shall be deprived of his property or liberty without the judgment of his peers, which was old English way of saying jury, a jury of your peers, the people, and not a judge, but the people. At the time we created this country, the founders thought that a lot of it went back to the Peter Zenger trial in New York City. But Peter Zenger was had criticized in the newspapers, an editor of a newspaper in New York. He had criticized the governor for being corrupt. And the king had passed a law of seditious libel, where it was not a defense that you call someone corrupt and you could prove it was true. If you just call them corrupt, any kind of slander against a person was viewed to be a crime. And so the king got his judge, the governor got the judges he appointed to go after and try to convict Zenger, but he got a jury trial, and he was represented by a very prominent trial lawyer who argued to the jury that the jury was the only thing that stood between the average citizen and the tyranny of a strong central government. So the very idea of the Seventh Amendment was like, okay, the juries are going to be the fourth branch of government. And if we have a corrupt central government, whether it be the king or a federal government, there was a lot of suspicion about the power of the federal government back when the Constitution was adopted, that juries will protect the average citizen, because you can't corrupt a jury, you can't fix them, you don't know who the jurors are going to be till you walk in the courtroom. Whereas judges, you can buy them in advance. And so virtually every state then and every state now has in the state constitution a right to a jury trial in civil cases. So this is a widespread right that we have had from the very beginning. Now, a lot of things explain why this right, which was so precious, and the Constitution would have never been adopted if it were not for the fact that those who went along were promised that when they passed the Bill of Rights in 1791, they would include a provision guaranteeing the right to jury trials in civil cases. And that was passed. And the Supreme Court has written very little on that right. It is a right which today is not, virtually all of the other Bill of Rights have been incorporated by reference, so the states are bound by them too. But the Supreme Court has never held that the Seventh Amendment was incorporated to these states. So the states are free, if they wish, to do away with the jury trial, although there are very few states that have done so. Most of the states are as committed to jury trial, state courts are, as the federal court has been. So this was kind of at the beginning. And then over time, a lot of developments took place. The country from which we inherited a jury trial in civil cases has done away with it completely. And that began in World War I because the people who were serving on jury, the men, were going away into the service. There were not enough people to serve on juries. And they just eventually did away with them. So today in England, the only kind of civil case in which you have right to a jury trial is a libel case. You have them in criminal cases, but no other civil cases. They're all judge cases. Another thing they did in England was they had a new category. Instead of a corrupt category of judges appointed by the king, the new king at the turn of the century appointed and set up a procedure for appointing very prominent senior trial lawyers as judges. So you trusted the judges more. And the question is, in this country today, I mean, there are a lot of objections to the jury trial. They take too long. They are too expensive. They are too dangerous and uncertain and unpredictable. We can't get enough people to come out to serve on juries. Only 20% of the people subpoenaed even show up at the courthouse. And the bar and the bench have been complicit in engendering this fear among lawyers primarily and legislators that it's not fair to subject a company to the danger of the jury trial. And this, by the way, is woven, this is in all areas, not just patent cases. Patent cases, you have the additional problem of the complexity. Mm-hmm. I mean, more than any other case. It is a complex case. Right. But every other case has the same kind of thing. So that the courts have developed a series, federal courts particularly, this series of doctrine which are designed to protect defendants from having to face a jury verdict. Enhanced pleading, liberal summary judgment, difficult to get a class certified, creating the judge as a Daubert gatekeeper so that the juries can't hear some BS expert testify. Everything's designed to protect a large company from a better company case having to present it to a jury. And, I asked a federal judge in New York recently at a social event why it was that the Supreme Court seemed to be so hostile, all the appellate judges, to juries. And his answer was obvious, but I had never thought of it. Of the 9 justices on the Supreme Court, only one, Sotomayor, has ever tried a jury case. And what they see up there are the outliers, the outrageous cases, the McDonald's cup of coffee that's overheated that spills on them first. The runaway jury verdicts. They don't see the 1,000 of verdicts that are handed down every month that are right in the strike zone. I mean, they just see the outliers. And what they see, they don't like. So that they have developed all these rules to make it difficult to not only get to a jury, I mean, the vigor with which they, if you just think about it, one of the reasons that jury trials, this is kind of funny, the case where jury trials must be perfect under the Constitution are breach of contract cases. That is clearly a common law case, not an equity case. And it's not a statutory case. And yet, as Justice Scalia has said, there's no common law anymore. It's disappearing. There's no common law because all disputes are resolved in arbitration. There are no opinions written. It's all in secret. And they're resolved by these mandatory arbitration clauses where you, the average person, you can't buy goods or services today without giving up your right to any kind of trial, jury or non-jury. You go to an arbitrator. And a recent study was announced last week by the Consumer Protection, the new Bureau, and that said that of the people who sign arbitration clauses in contracts, only 7% are even aware they have given up their right to a jury trial. They either don't know an arbitration clause was in there, or they think that, well, that's just one alternative. It's not the exclusive one. But today, we live in a world where the Supreme Court has gone, they just granted cert in a case out of California today or yesterday. Yes, this morning. They did it yesterday. This was Monday, yesterday. They granted cert in a case out of California where the California Court of Appeals had held that a arbitration provision in a contract was not enforceable because there was not a voluntary consent, and no one even understood what it was hidden in reliance on California law. And the court, obviously they think that it's an attack on their cases, which say that the Arbitration Act is supreme law. The Federal Arbitration Act prevails over any state law, the contrary, and so the enforcement by the courts of arbitration clauses is another reason why we are jury trials are vanishing. It's a fact in every area.
So, Ray, could you tell us a little bit about why this is such a raging debate in patent cases? In particular, both of you to talk about why it's particularly...
Well, I think there's this preconceived notion,
vociferous
and
in our...
Steve alluded to it, that patent cases create special challenges for judges and juries because of the complexity of the technology. Frankly, I don't buy into that. I think that a jury that's properly instructed by the trial judge and is subject to an organized, effective presentation by the lawyers can understand the technology as well as the judge, maybe better, because one of the beauties of a jury is you have 6, 8, 10, sometimes as many as 12 sets of eyes and ears that hear the evidence, judge the credibility of the witnesses, and make a determination. I've always viewed it kind of like this. If there was an accident that occurred out on the street and 10 of us saw it, the odds of, and we could discuss it, the odds of that 10 coming up with a good explanation as to what happened are far better than if just one of us saw it. So there's a synergistic effect that takes place when you have a jury. I want to give you one anecdote, and I mentioned it to you earlier, about underestimating the skill sets of the average ordinary guy. Now, I tried a case in Silicon Valley where 6 of the jurors, we had 10, 6 of the jurors had advanced degrees, some in computer science, of course, that's Silicon Valley, and 8 had bachelor's degrees. So you had a very educated jury. And they got it. They understood it. They understood the technology. They understood what the presentation was. But I tried a case involving pretty complex electronics technology. I think, as I mentioned, one of the jurors, young fellow, said that he hadn't graduated from high school, and he went through the equivalency requirements in order to get his high school degree. And I personally viewed it as he wasn't going to be a factor. He was going to go along with what everybody else said. Badly underestimated what the reality was, because what he didn't say and didn't explain until the verdict came in was that he had spent his childhood, his passion was electronics. He was one of these guys that took the ham radios apart, did the sort of things I understand you do, Rob. But he knew and understood electronics. And he said afterwards he resented the fact that the defendant's lawyers were talking down to him and to the jury. And he went on to explain how he explained to the rest of the jurors how this thing worked. Now, how do you figure that out? Well, the synergistic effect of juries never ceases to amaze me. And I believe the system works, and it works well. And in my experience, most judges that try cases and preside over cases will tell you that, in their view, juries get it right. And if they don't, the judge will fix it. The Court of Appeals will fix it. So I have trouble with this notion that there's this big threat to society because juries are allowed to decide cases. I don't buy it. The threat to society comes from the other side. You have an elitist group that believes they're smarter than everyone else. A lot of them are academics. And they publish this notion that, and many of them are on the payrolls, I think, of some of the big corporations in America, as we're now finding out. Some of the people that write these articles are secretly being paid hundreds of thousands of dollars from major corporations. But be that as it may, what you have is, on the one side, you have the elitists driven, I believe, by major corporations. On the other side, you have individual inventors and small companies that have been the lifeblood of economic growth in this country. The reality is that most jobs come from small companies and the development of ideas from those small companies. How long ago was it that Steve Jobs and Steve Wozniak, a couple of guys working in a garage, created Apple Computer? How many jobs were created from that idea? Lots. But now that they're rich and famous, they don't want jury trials. They don't want the little guy to have a shot.
Right.
That's the reality. You get a couple of guys in a dorm room at Stanford that create Google, and a guy in a dorm room at Harvard that creates Facebook. Those ideas, those creations of individuals, result in economic growth for our country. And what we're killing here, and threaten to kill through this talk about getting rid of juries, getting rid of cases, getting rid of patents, let it all go to the patent office. What we're forgetting is we are undermining creativity and innovation in our country, and we're slipping into a second-class citizenship, I believe. Now, I want to comment on Steve's comment about the McDonald's case being an outlier. I don't believe that. I think when you look at the history of that case, that it was a just decision by the jury and the judge. This woman was badly injured. She was burned, first, second, third degree burns, from coffee that was deliberately made at a temperature that was unsafe. McDonald's had a history of doing this, so it wasn't the first time. It happened repeatedly before. And the judge who oversaw the case agreed. He trimmed the punitive damages, but he let the underlying verdict stand. Why was the McDonald's case so famous? You know why? Because special forces decided that was going to be the poster child for tort reform. And they got it. State legislatures across the country changed the whole dynamic of torts in the United States. There's a new villain in town now. McDonald's is to tort reform what patent trolls are to patent reform. All you hear now
Very good point, Ray.
are trolls are bad.
You must have
trolls
been
do
listening to
this.
the webinars.
Yeah, I have. I think I said some of the things about it. So what you have is a propaganda-driven notion that just like McDonald's was a bad decision and trial lawyers should be punished for that and we should have tort reform, you now have patent trolls, non-manufacturing entities they've morphed into, should be wiped out because, and Congress buys into it. Why? Because there are 5 companies driving this ship. I'll name them. I'm not going to pull back. Google, Apple, Cisco, Intel, Microsoft, right there. Those 5 companies contribute so much money to creating the propaganda that invention should be the exclusive domain of the big guy. That's bad for our country. Now, I've digressed from what you asked me, which is jury trials.
Well, we still have, to follow your point for a second and bring it back to the legal side, even though I am the business commentator, do you think that a jury trial influences so usually you have the plaintiff as the inventor, right? And you have the
Or his
bigger
company.
company might be the accused infringer. In terms of economic impact, do you think that the jury trial will, that the decision to take a jury trial will be influenced by the fact that a jury might side with a plaintiff,
Sure.
with an inventor?
I think
How does that play out? Maybe
one of the goals of any trial is to resonate with the preconceived ideas of the people that are going to be judging it, be it judge, jury, whatever. And I always make a point of kind of doing a random survey before a trial. I'm in a restaurant talking to the waiter or waitress, and I ask, they'll say, "What are you doing here?" "I'm going to try a case here." "Oh, that's good. What are you going to try?" "Oh, this, that." And then I ask them the question, how would you feel about being an inventor and somebody took your ideas and used it? "Oh, that's what big corporations do. I'd never disclose my idea to a big corporation." Well, that's a bogus point of view. But it tells you that a lot of people think that. And if they think that, they may come in preconceived, loaded in your direction. Now, are they going to decide the case that way? I don't think so. I think the jury properly instructed is going to do what's right. I'm not an expert on that. There have been jury studies galore. They've done a bunch in Chicago way back when they concluded that opening statements, that 85% of the cases decided by juries in Cook County, Illinois, 85%. After the closing argument, they did a survey. Who do you think is going to win? And in 85% of the cases, the people they thought were going to win after the opening statement won the case. Now, does that mean everything that happened after the opening statement didn't count? Maybe not. Maybe it was a coincidence. Who knows?
Steve, do you think that the accused infringer is disadvantaged in a jury trial?
No. Well, the statistics are that, this guy, Mark Limley, Professor Mark Limley at Stanford, did a study, and I have it right before me, in the AIPLA Quarterly Journal, spring 2013, Rush to Judgment, Trial Length and Outcomes in Patent Cases. And and it was a pretty good empirical study because he's using 674 cases to look at that actually went to trial. 75% of cases actually went to trial were jury trials. The other 25% were bench trials. Bench trials, yes, the plaintiff won about 62% of the time in bench trials and about 70% of the time in jury trials. Here, this graph here, I don't know if you can see it, but you see this bar right here? It's not that big of a difference. So yes, clearly the plaintiff has an advantage in a jury trial. It is also true what he found out was that jury trials take on the average 8 days and bench trials on the average 5 days. So bench trials, according to the study, are usually quicker, but we can do something about that. My problem with Ray's approach is Ray is preaching to the choir. I mean, he's talking to the plaintiff's trial lawyers like me who believe in jury trials and who buy his stuff, but he's not going to convince anyone, okay? Because he's for the little guy, he's for the inventor, and that's fine. My approach is more to get my allies both on the right and on the left, both from big business and the plaintiff's bar. My practice is about 50% plaintiffs, 50% defendants. Although in intellectual property, it is all plaintiffs. But in other commercial cases, we represent many, many defendants.
Are you continuing to have all plaintiffs in the patent side? Are you going to continue 100% plaintiff on the patent part of your business?
I think the question there is whether we continue in it at all.
Okay, that's...
Because I am very nervous about these reforms. I think it's very, very difficult now. It's very risky to take a patent case on a contingency basis for a plaintiff.
Can I just interrupt you for a second? I completely agree. We're going through this exact same analysis where we've concluded that the risk of taking a patent case to verdict or judgment is so high because even if you win, you're likely to lose at the federal circuit and, or worse, lose at the patent office. I mean, somebody just had a $44 million verdict set aside by the patent office. So why play this game? Why even take patent cases? So I think you're going to see
worse than that, as you know, the new law, the reform law. And we've been all this reform, tort reform, securities law reform, patent reform, antitrust law reform, it's all designed to protect businesses. All Chamber of Commerce motivated to protect the business from the uncertainties, the vagaries of a jury verdict. Okay, I'm convinced that we didn't have jury trials in civil cases, you wouldn't see all these reforms.
Right.
These reforms are being pushed by the fact that we have a Seventh Amendment, which is a problem, and we need to focus on it. So, I think that my view is that what happened in the patent area, frankly, is one of the biggest objections to the jury trial is the length of time. The more time the trial lasts, the more money it costs, and you're paying jurors too. And so lawyers have let that get out of hand. So, and judges aren't doing much to help us. I say that the solution to all our problems, including the problem of jury trials, is for judges to, like they do in the Eastern District, brings me in the Eastern District of Texas, where we're sitting very close to it right now, if not in it here, is that we had a couple of judges in the Eastern District of Texas, Judge Ward, Judge Davis. They got tired of doing rear-enders, diversity cases. There was no real criminal work here and no major business cases. And they somehow, I don't remember how Ward got into it, but he got into enamored with patent cases. He thought it would be, and he and Judge Davis and others, Folsom and Gilstrap now, designed a set of rules and procedures, most prominent of which is you get an early trial date and you get a very quick trial. It means each side gets 2.5 days. This was tested, and people found out the statistical results are in now. While there's a higher win rate for the plaintiffs in the Eastern District of Texas, it's not because they have a higher win rate before the juries, it's because the judges aren't throwing out the case on summary judgment. They are getting to juries. So the win rate's not so higher than it is in the Central District of California or Boston for the plaintiffs. It's just that judges are not granting summary judgment. But these judges came up with procedures that show that you could do cases quickly. And so right away we began, if you can do them quickly, you begin removing a lot of the objections. I tried a jury case in a securities case in New York last year that lasted 6 weeks. And because it was a 6-week trial, the people we had on the jury were largely retired or unemployed. I mean, people who are professionals, who have important jobs, white-collar people, can't afford to spend 6 weeks in jury duty. So you aren't getting a jury of your peers to begin with. You're getting the lowest common denominator who can afford to sit there for 6 weeks or six. I've just been asked to do an appeal in an antitrust case that went on for 6 months. And you wonder now, what kind of judge, how could it go on for 6 months, a case? There were like 6 issues. But in any event, it did go on for 6 months. So we need to get the judges and lawyers comfortable with the idea that you can get a just result, the same result in a 5-day trial that you get in a 5-week trial. And the empirical evidence that's studied by Limley, again, proves that. There was no correlation between the length of the trial and whether the plaintiff won or the defendant won. I mean, it doesn't really prove it because you have to try the same case, but at least the same win rate for plaintiffs in long trials as in short trials.
So the courts can regulate that.
They have the power to do it, but
they do. Take a look at the Eastern District, Virginia. I've tried 6 cases to verdict there. The average time of those cases, in complex patent case, one was a patent and antitrust case, 3 days. We learned to put our case on in 3 days. I don't care how complex it is.
15 hours.
And you know what? Your observation, 100% right. I came to the conclusion that going longer wasn't going to change the result. And the judges of that district make it a point that you have to move the case along.
So you can convince, we should be able to convince the business community, because they are spending, the business community is today spending hundreds of millions of dollars with jury consultants.
Follow that model.
Mock trying a case,
trials.
okay? They mock try a case in a day, and the reason they are willing to pay $125,000 for a mock trial that lasts 1 day to a jury consultant is that the lawyers, both defense lawyers and plaintiffs lawyers, are going to say to them, you get a very accurate prediction of what a real jury is going to do. You get lawyers from both your firm to play both sides, get up there and present 2 hours of an argument each side with documents and some deposition excerpts, and watch 36 people in 3 groups go behind, one-way glass and deliberate. And you can tell whether you can. I have never been able to change the result of a mock trial, ever. I mock trial all my cases. I mean, if I lose in the mock trial, I'm going to lose it in real world, or at least I'm comfortable enough that I probably will settle it. So I believe that that's empirical evidence that if we went about it in an organized way, we could convince businesses that jury trials can be less expensive than bench trials. Bench trials are stop and start. The judge will, you have to go to New York and stay in a hotel because the judge is going to hear you 2 days this week, 3 days the next week. You skip 2 weeks, another 2 days, which costs the client. You've got to bill the client for travel or wasting your time in a hotel room or getting up to speed because of all the interruptions. Where most judges, if there's a jury, will try to get the jury, at least they're cooperating with them through. So that's something, the speed, we can do things about. We have to be innovative. I mean, we have anyone sitting, if you are a general counsel that walked into a courtroom in New York or Houston or Dallas, a federal courtroom, and walked in from Mars, and you heard the jury being instructed by the judge at the end of the case in a patent case or antitrust case or securities case, you would scratch your, if you were Brandeis, you would scratch your head and say, I have no idea what he's talking about. Okay? We have let these instructions become so gobbledygook, such a conglomeration, that no jury can possibly understand them. And how can you have faith that these people are going to follow the law if the law as articulated by the judge is incomprehensible?
There's no reason for that.
There's no reason for it. We have done everything in our power to make it difficult for jurors to reach a good result. There is increased experimentation now with question asking by jury. But many judges are reluctant. They think it's going to delay it too much. They're worried about letting the lawyers know how jurors think, about the questions that they ask, which I think is a great thing, because now the biggest complaint the jurors have, two biggest complaints the jurors have. The first one is jury selection. I'd like to talk about that a little too. That it's intrusive and it's time consuming, and once they get on the jury they don't mind, but it's the day or 2 days they spend at the courthouse waiting to be picked. They hate it. And the second thing, biggest complaint, is repetition. The lawyers are repeating over what do they think we are idiots that they have to repeat this so many times? We repeat it because we have no idea what they're thinking. You're worried that they ain't getting it. If they could ask questions, you can know whether they're getting it, or know where you have to put on more evidence or repeat something. So question asking by jurors is great. It was an article in yesterday's USA Today. I recommend everyone look at it. It's about the Payo trial against the investment firm in Silicon Valley. You know, the Door,
Right.
That venture capital fund. The woman,
John Doerr.
the woman who's suing them for discrimination.
Sexual
It's in court in San Jose.
Perkins, Kleiner Perkins.
Kleiner Perkins, that's right. And this reporter does an incredible job. She said, listening to the jurors, being able to ask questions to John Doerr, who is a man who obviously doesn't talk to common people, and making him explain gave her renewed faith in how important the jury is to the feeling of civic responsibility. And we ignore that a lot. So, but questions, we don't let them make questions. We don't let them talk about the evidence before they go into deliberations. What kind of class would you go to where you can't even talk with your fellow students about what you learned from the teacher that day? Or can't ask questions? And only recently could you take notes. Only recently
can't take notes.
Well, I would.
And the instructions are not given at the front. They're given at the end. Like, okay, so spend 3 weeks trying to put this complicated piece of machinery together, and then I'm going to give you printed instructions on how to do it.
And no mini summations. See, I don't care about questions. To me, questions are misleading. But I'll tell you what I think is critical. Judges that let you do a mini summation,
Interim argument.
as the case, interim, what do they call it?
Interim argument.
Interim argument. I call it a mini summation, but basically most judges won't let you do a closing argument. But you can get up and say, all right, ladies and gentlemen of the jury, you're going to hear testimony from Mr. X, and this is important. This is important to our case because of this. So he's going to testify to this, and so you create a picture of an expectation of what's coming and why it's important. They don't have to wait 5 days to find out why. They find it out now. The other side gets up and say, well, it's not that important because you're going to hear from another guy later that's going to say this. Okay, fine.
During jury,
at least they're getting it right.
How about this? During jury deliberations, the foreman sends out a question. We would like to know what witness X said on this subject. And the jury knows that the judge has
Use your
a transcript. The judge has a daily copy.
Right.
It's reading on the screen. They know there's a transcript.
I never understood that.
And the judge says, no, I'm not going to take the time. Go use your memory. Or the jury says, I don't understand what is meant by intentional. The judge says, well, I'll read the same instructions to you that I did before, which raised the question in the first place. In other words, judges and lawyers have allowed the jury to become a horrible institution. We have to do something to revitalize it, to get it back to its rightful place, and I think we can do that.
See, judges will say you don't want to emphasize one portion of the trial by reading testimony from that
They have every
portion. But if the jury has a question about something, why not answer it? I agree. Let them answer it. Help that jury. If you were going to a classroom, Steve alluded to it, and you're going to take a course in chemistry or whatever, and the professor comes in and says, all right, we're going to do a little experiment here. We're not going to use a book. You're only going to hear from me and maybe 5 of my colleagues going to talk to you about chemistry.
You can't take notes. You can't ask questions.
For 2 weeks, you can't take notes. You can't ask questions. You can't talk to each other. And I'm going to tell you at the end of the class, 2 weeks from now, what you got to decide and what's important and what's not. You've been shaking your head in disbelief. No way am I taking this course. It's insane. That's exactly what juries are required to do. It makes no sense. Now, the enlightened courts are helping jurors, and by helping jurors, you improve the probability of a just result, and that's what you want.
Maybe, I would think we need, it's heresy, but we should think about it. Jurors we all expect, when we have a question, we either Google it or ask Siri. Okay? Well, we want to know something. That's our life. Our kids
Don't you
do
think
that.
they
We
do that?
I not only think they do it, I think they should be allowed to do it. Okay? I think that, and that, by the way, the original juries, the idea of having people in your community was not that you would get dumbbells that had never knew about the dispute and didn't know the parties and didn't know nothing about it to come in and resolve it. You would get people who knew the plaintiff and the defendant, who were in the community and saw what happened or heard about what happened, and who were well-informed peers. Now you don't get that as jurors. So there's another reason to be suspicious of jurors. So, I think that we should explore and experiment that. Another thing we should experiment with is, if anyone has ever gone to jury service, the thing you hate most is the day or two you spend there. These lawyers, sometimes without supervision of the judge, do these lengthy voir dires, asking you about stupid questions about your life. And, people learn how. Everyone makes jokes about how you get out of jury service. They don't want to do it. So, but we should submit to jurors in advance over the internet questionnaires. We have the ability. We can find two people and match them, a husband and wife, over the internet now. We let people buy.
License the eHarmony
purchases. Why don't we select jurors? Do all the jury selection over the internet in advance. They are administered a questionnaire. They are told how long they will be there. Every effort's made to get the data about them from the internet. There's no problem with that because there's a lot of data out there. You let the lawyers, so you don't even have them come to the courthouse until they have been narrowed down to at least a pool of maybe 25. Maybe the lawyer should have a look at who they are or something like that. But you could speed up the process so much and save so much aggravation
using technology
by doing that, and we should explore that. But, so, in any event, what I was saying is, I think what has happened in the patent area is that the fact that we had these Eastern District judges and the Virginia judge in the Rocket Docket exploring these quick trials and short trials in the patent area, and the fact more recently that we have had a lot of defense verdicts in the Eastern District of Texas. It's no longer just plaintiff's verdicts. Leads one to believe that, maybe jurors can get it. Maybe they can do a good job. And we need to do some studies because, again, what I want to do is I want to persuade. I believe that if you ask 90% of the lawyers who are not trial lawyers, the 10% who are love jury trials, and usually both plaintiffs and defense lawyers. The judges who try jury cases, they love them too, because they will say, there are a lot of judges that say, it's great. Why should I spend 2 weeks working on summary judgments that are this high when I can impanel a jury, try the case in 2 days, get a verdict, get it out of here? So, the people who have tried it like it. It's the people who haven't that are very distrustful. And, of course, 90% of the lawyers are not trial lawyers, and they would, if you ask them, should we have a Seventh Amendment? They would say, I doubt it. We don't need one. Those are the people we have to convince. And there are 2 other reasons I'd like to talk about that are very important that people overlook. It is clear that one of the purposes of, and a uniquely American purpose of jury duty, which is a jury right, is it engenders a feeling of civic responsibility. There have been studies that show that people who serve on the jury are much more likely to vote than people who don't serve on the jury. because they have become part of the government for a short period of time. They understand what making decisions are about. And that's very important, and we should not deprive people of that right. The other important thing is that I'm not saying judges are corrupt, but with Citizens United being extended, as I'm sure it will be this term by the Supreme Court, to a judicial, we forget that 70% of the judges in our country, and the state court judges, are elected, not appointed. We patents, we're dealing with federal judges, who by and large are pretty good. I don't think we have to worry in the federal courts about judges being corrupt. It's the state courts where you can go buy a state court judge for, I don't know, $50,000 contribution, $25 contribution. There's no limits anymore. You contribute what you want. And the repeat users of the, and that's happened in some states. I mean, Texas was run by the plaintiffs' lawyers for years. It used to be the defendant's hellhole. Now it's the plaintiff's hellhole. No one wants to file suit in Texas because we have a completely Republican Supreme Court. It's happened in Alabama, Mississippi, Wisconsin. Other Supreme Courts have, big money has come in and taken over the court system. And so the original fear of our founders, that juries will protect the average person from the corrupt judges, or judges who are already prejudiced, and there has been empirical study on that a judge who receives a contribution from the Chamber of Commerce or a business in the Chamber of Commerce is much more likely to rule in favor of business in a case than a judge who has not received those contributions. So there's a correlation there. Anyway, I think we need to hold on to our juries until we get rid of Citizens United or get rid of elected judges, because I do think there is a great deal of protection for the average citizen.
Well, let's talk about an area of patent law where we have a parallel process, validity. So we have validity cases in the district court, and we have validity at the USPTO. One has the right to a jury. The second one at the USPTO doesn't. Do you have any thoughts about why the new AIA IPRs and CBMs do not, what the effect is of not having access to a jury?
It's another hurdle. You see, Professor Lemley talked about fractionation of patent cases, creating an impediment to winning a case for the plaintiff. And indeed it is, because when you think about it, if you were running the high hurdles and you had to clear 20 hurdles, there's a chance that you're going to trip on one of them. And if you trip, you lose. The idea at the early stages of my career was that you present everything to the jury. Jury decides the case. Well, along came Markman. Markman became a fractionation, a multiple fractionation. Every term that a defendant wants to put up becomes a hurdle. If you trip on one of them, game over. So now you've fractionated the process into 5, 10 different hurdles you have to clear. What's another hurdle? Right at the beginning of the case, you've got motions to dismiss based upon the Supreme Court's Twomley case. The complaint isn't specific enough, doesn't give us notice, even though the federal rules of civil procedure provide the bare minimum of notice. You now have to get more specific in order to survive that. Now, you have all the summary judgments. Alice has added a whole new dimension of summary judgment. Now we find that almost all software patents are not patent eligible. They were eligible until Justice Thomas decided, or the Supreme Court decided, that patent eligibility now has to be re-examined. Now you have a whole new hurdle that you got to clear. If you have anything that's an idea driven by software or over the internet, which interestingly is the large portion of the kinds of patents that have been issued. I think the government study on NPEs and their impact on litigation showed that 89% of new patent cases were software-related patents. So that 89%, by and large, is going to be subject to an Alice challenge. Now you have a Section 112 challenge, claim definiteness.
Right.
You've got a challenge under Section 103. And now you get to the point where you're going to have a trial, you hope. And what do you find? Dalbert. Your expert's no good. The expert hasn't considered reliable sources, and his opinion is unreliable. Now, you got to clear that hurdle. So you get to trial. You know how many cases get to trial? Very few. The statistics, and we're talking all cases, show that 40 years ago, something around 15% of all cases that were filed got to trial. That number is less than 1% today. Less than 1%. We've gone from a country where 15% of your cases could get to trial, whether it's judge or jury, to a country in which 1% of all cases get to trial. What happens in the process? What's happening in the process is that these cases go away because of the fractionation in the patent instance, and I think in other cases, go away at some point in the process. Is that right? I'm not so sure it is. I like the idea that the Eastern District of Texas has. Let the jury decide it. If there's a mistake, if the case is so out of bounds, there's a judge sitting there that's going to fix it. And I think a judge who says, instead of me having to decide all these fact issues, I'm going to let the jury decide it. And if I think there's an error of law, I'll fix it. And you see the Eastern District of Texas judges doing it all the time now. I have a friend at Eastern District of Texas, tries a lot of cases down there, and I'm not going to mention his name, but he's a pretty prominent guy. He said, our jury pool is poison now. This whole notion of the trolls and the NPEs and the bad things they're doing have changed the dynamics of, and there aren't that many people there, so you get a lot of repeat jurors. And you may have a poisoning because of some of the big business interests. I hate to be so cynical. You know, I started representing big corporations. And I would say more than 50% of my business was big corporations. And I got a little disillusioned with that process. And I'll tell you why. It came to me that all I was doing with my life and what skills and talents I had was moving money from position A to position B, or defending the movement of money from position B to position A, whatever. It also occurred to me that the only person that cared about what was going to happen in the case was me. I didn't think, despite all the best energies and efforts, that these guys that hired me and paid me by the hour to do it cared. So I said, you know what? I'm going to change my life. I'm going to try to help some people. And I sleep better at night now, too. Although recently I've been sleeping so well. This is what Jerry Spence said. I want to read this to you because it's fantastic. They asked Jerry Spence what regrets he had in the practice of law. He's a pretty articulate guy and a good trial lawyer. And he took off on corporations. He says, in short, the justice system is broken. It does not deliver justice to the people, most of whom are poor or are teetering on the threshold of poverty. The system is the handmaiden of corporations, those non-living fictions, some of which are so gargantuan their assets exceed those of entire countries. Bullets, knives, axes, and even bombs cannot kill these monsters. Only money moves them. They live on money, digest money, and excrete money. If money is taken from them, they will starve and eventually die. They poison the earth for money, poison people for money, wage fraudulent wars against innocent people for money. The problem, of course, is they are like a creation out of hell. They have no soul. That's pretty strong stuff. But you know what? He's not too far off. A lot of these guys that are creating this hysteria, and with all due respect to Professor Lemley, I have to say I was shocked to find out that it was revealed through discovery in a recent case. Unbeknownst to anyone, who do you think is paying Professor Lemley substantial monies for consulting fees? Google.
So let's
So is there objectivity in this data? Maybe there is, but sure would raise a question in my mind as to how objective some professor is when the professor is on the payroll of a major corporation who's made it its mission to send a message against invention and inventors.
So let's talk about innovation, because that is one of the big themes of our webinar series and our conference that you both are involved in, and on April 23. Please attend, everyone, in Silicon Valley. So let's talk about innovation and why, with innovation being oftentimes the province of the individual, the garage, the famous garage in Palo Alto for HP, for example, the garage we see now on television ads for Amazon, right? All these garages. Why is it that the innovators of this country, the little people, lose sight of the importance of the Seventh Amendment, the importance of being able to try their case in front of their peers when they become wildly successful? Why is there such a rejection of the patent system, of the Seventh Amendment, by these super successful innovators? You would think, with foreign competition being what it is, particularly from China, that the innovators in this country would be deathly afraid of the future.
It's money. What Jerry Spence said. The forces that are after this reform are after it for money. They fear the consequences of a quote-unquote jury trial that might find them liable, and they're trying to figure out ways to cut that back. They also want to reduce the number and volume of litigation, and they've been pretty effective in doing that. When you think about it, when you see 20 to 40% drops in patent cases, that's telling you what Steve said and what I happen to agree with. It's not worth the fight. You cannot win the fight. If you win the fight, if you have the good fortune of getting through the myriad of hurdles you have to clear, getting a trial, winning the trial, and now you're sitting there as Vernetics with $368 million, blessed by the district judge, and you go to the Court of Appeals, and it gets reversed because the expert didn't consider the smallest saleable unit or these fictions. You know, I have to say, with all due respect to Judge Rader, who was driving this damage stuff, he made the comment that the reason you can't measure damage by the entirety of the product is a little like this. You have a house. You put on an addition to your kitchen. You sell the house. Is it reasonable that you would base the value of that addition on the price of the house or the price of the addition? Well, that's a pretty simplistic and reasonable approach. Let's apply it to a patent case. I've got a phone. I don't know what I did with my phone. I've got a phone. It's an iPhone. In there, buried in there, is a microprocessor. It performs 20 different functions, only one of which relates to the patent. How do I allocate, in this hypothetical world we have to live in, for damages, what the value is of the invention that's implemented through a microprocessor that does 20 other things? You know what? It's the ultimate challenge. It's impossible. It can't be done. And if it can be done, you're left with such a minuscule amount that it's laughable. Well, what happens? You hit $368 million. You go to the Federal Circuit, and it's gone like that, poof. Or, worse, you go to the Patent Office. 8 patents in a $44 million verdict. 8 patents get set aside in an IPR. What are we doing? We got a group in the Patent Office that issues patents and another group that takes them away. Mm-hmm. And with all due respect to Google, let's be realistic. They've seized the Patent Office. They manipulated themselves into a position where their people now run the Patent Office. That's not an accident.
See, I feel totally uncomfortable sitting here listening to Ray. Because he's a guy who is very passionate about his side of the docket, but his passion for his side of the docket is, I believe, one of the causes we have a problem in this country. That the plaintiffs' lawyers overdid things. They overreached. We were engaged in too much forum shopping. We pushed crazy damage theories too far. There were other things we did as plaintiffs' lawyers that we should have done. And I think the problem when I believe we will get more result if we do not challenge the credibility of big companies or their intentions, but we try to work together on what the problems are. I think there is a problem with frivolous litigation. There is a way to deal with it. It does not involve placing on the losing party the burden of proving that your lawsuit was well-founded in fact and law. The burden ought to be on the person seeking attorney's fees to prove that it was not well-founded in fact and law. And, I'm not worried about punishing people sanctioning them for filing really frivolous lawsuits, but it shouldn't be a law that allows you to punish someone for losing a lawsuit. And that's the way the law is being worded. So, I think we ought to go in there and say, okay, we're against frivolous lawsuits.
Right, but just on what Ray was saying for a second, it occurs to me that it's interesting that if it's true that an incumbent power is influencing the USPTO, that's also the organization that does not have a jury option for the same process that's tried in the district court, which was my original question, is what do you think the effect is of not having a jury at the USPTO on validity when you do have a jury on validity in the district court? And why would we have parallel processes? I think we're the only country that has parallel processes, if I understand. And why does one have the right to having your common man help make the decision, or your peers, and the other not, when it comes to validity, which is, frankly, becoming as dangerous as enforcement proceedings without injunction, because any patent can be subject to a validity. It doesn't have to be a bad patent, and no one's proved. The USPTO talks about bad patents being taken out, but any patent is subject to...
I don't really worry about the fact that a patent which is granted administratively by an administrative office can be taken away by an administrative office in essentially an administrative non-jury proceeding.
At what rate? 97%?
I don't know.
Telling me that 97% of business method patents are invalid, then what is the Patent Office doing? What administrative agency of government is wrong 97% of the time?
Well, I don't know. What the real question is, what impact on innovation would you have if 90% of the patents that have been granted were not granted? Okay? What if the grant rate had been 10% rather than 100%?
Then fix it before they get out there. That's the Patent Office's role.
I would agree with that. That would be fine. We should do that. My general idea of these IPRs and things is fine. If the guy, I'll be there to represent him if he has a valid patent. He's got to get through the hoops. And there may not be many clients, but that's why my practice may go away, because instead of having 100% of the pie, I have 10% of the people who are even calling about cases that have gotten through this process. But it's not offensive to me. And by the way, it's very interesting. Yesterday, I know about this because I read it this morning, and I was asked by, Law 360 to comment on it. The Supreme Court yesterday decided an important trademark case, which was a 7-2 decision, which said that a decision by the Trademark Appeal Board is preclusive of a decision by a court and a jury. And the Supreme Court said that's fine. That's no problem. They had no problem with that idea. And they did say in the opinion, by the way, it was very interesting, the opinion said the petitioner has raised a Seventh Amendment issue, whether this is a denial of their right to jury trial on the Seventh Amendment. But we will not address it because they didn't raise it in their briefs. They raised it for the first time in our argument, the Seventh Amendment issue. And I'm kind of glad they didn't raise it, because God only knows what the court would have done had they addressed the issue on the merits.
Right.
The justices who dissented were Scalia and Thomas, who took the position that it was an intrusion on the power of federal courts, who are supreme under Article III courts, to allow an administrative agency to bind what a federal court can decide. It's very interesting. I mean, I did not know this until this morning when I began preparing for this program and last night reading some literature, that, I've always assumed that patent cases, there's a constitutional right to a trial of a patent case. That's not so clear. The Supreme Court has certainly never held that validity, there's any right under the Seventh Amendment to try validity. And Lemley, I did not know his research was sponsored, was
I may have overstated that, but there was a decision that just came down in a case involving Google, in which the other side, I think Professor Lemley may have been an expert in the case, and they were trying to show that perhaps his views may not be totally, and it was an advocacy kind of thing. So they dug up and forced Google to produce documents showing that they paid him. That doesn't mean that his report. I have the greatest respect for the guy. I think he's academically solid. He's done some fundamental research that is very good. And I, by the way, agree. There have been bad actors. There has been forum shopping. There have been bad cases that are brought, and courts have the power to correct these kinds of abuses to the extent that they exist through the process of imposing sanctions. But you see, what's happened is exactly what Professor Arthur Miller said in this article entitled "Simplified Pleading, Meaningful Days in Court, etc., New York Law Review." He said something, when he was a young lawyer, he was asked to go out and figure out why are there frivolous cases and what's a frivolous case. And here's what he did after his study. This is what he concluded. And he says this. This isn't Ray Nairo speaking. This is Arthur Miller. He reported back to the committee, "I could tell them with considerable confidence that according to the practicing bar, a frivolous lawsuit is any case brought against your client, and litigation abuse is anything the opposing lawyer is doing. Unfortunately, because of cases like Octane Fitness and others, there's been a spotlight shining on every case that a defendant wins or the plaintiff loses or vice versa. And it becomes a frivolous position. It wasn't frivolous at the time. I sat at a conference with a very sophisticated lawyer from a big company, and she said, we had to spend $15 million in 5 cases brought by these evil NPEs, and they were all frivolous. And I said to her, if they were frivolous, why did you spend $15 million? Why didn't you get rid of the case for $1,000 or $10,000 or even $100,000? These cases became frivolous after the fact, not at the time they were brought. And that's what's happening. That's the real world. The real world is, if you don't win, namely you lose, you're going to face or your client's going to face the consequences of the imposition of fees. Now, why is that bad? I'll tell you why it's bad. It's okay to shift fees across the board, and that's what you're going to hear. Everybody's going to be bound by this. Okay, I'm Apple Corporation. I have $150 billion in cash. It earns interest at 5% per year. I make $20 million a day. A day. Do you think I care if there's a shifting of fees for $6 million? I'm individual inventor of small company. I have a small business.
University.
or a university, and they shift fees for $6 million, I'm out of business. That's why it's not right. It's not right because it deprives, effectively, everyone the opportunity to be heard. Because as our business goes away and his business goes away, who's going to represent these guys? You know who's going to represent them? No one. Or if there is someone, they're not the elite of the business. And therein lies what I think is the biggest problem that we face. The people that invent, and you don't have to have a laboratory sponsored by the government with big buildings in order to invent today. Some of the great inventions come from a guy sitting in front of a computer screen, acting independently on his own. What are you going to do? Put him out of business? I think so. Or in a university. How can the universities afford the process? Bad enough they got to pay the $3 to $6 million to get through the process. Worse, that if they lose, they got to pay another $3 to $6 million. They're not going to play the game. They're out of business. Is that good or bad for our country? Nobody's asking that question.
We're asking it. We're asking it in this webinar series. We're asking it at our April 23rd conference. This is that's the whole reason, frankly, for this whole effort is to talk about innovation. So,
and I'm sorry I'm making Steve feel uncomfortable.
It's okay.
But we are. But seriously, we are asking that fundamental question from everyone. Every view is welcomed here. I mean, how is innovation going to occur? That's the big
By the way,
question.
big companies, I don't think are a problem if they're innovating, because the issue is, are you driving real revenue growth? Because that's what you need to do.
Well, it's an overstatement to say all big companies are bad. I mean, what Jerry Spence said is an overstatement.
Sure.
And what I've said to a large extent is an overstatement.
Right.
You've got to look at the specifics.
Right.
There are some instances where big companies misbehave, and some instances when little guys misbehave. And misbehavior is best handled by a district judge or a court of appeals that see what's going on and address it. That's the way to deal with it.
Well,
you don't need legislation to fix it.
Yeah.
Let the judges that hear the case decide.
So we have to watch our time. What I wanted to ask you, Steve, because you are so proactive in everything you do, and you're trying to build consensus, you're trying to build meaningful change and reform. Tell us more about what you're doing in this regard, particularly at NYU and everything else that you're going on, because one of the purposes, frankly, for this webinar series and the conference is to have a call to action, to really address innovation and how we can encourage innovation in the United States for the next generation. I mean, that's why we're here. It's not for lawyers or for big money people to make money. It's for the innovators to be able to innovate. So talk to us about that.
I got involved because I thought that as I got older and got tired of trying lawsuits, I might teach trial advocacy. But then I realized, why would one want to teach dinosaur hunting? The dinosaurs are disappearing. If I would more fruitfully use my time, if I thought about how we try to de-extinct the dinosaurs or keep the last ones alive, or maybe even revive the dinosaurs, jury trials. And that got me into thinking about, well, the problem is not so much all these games that lawyers play in trial advocacy skills. And the young lawyers come to you and say, I want to learn to be a trial lawyer. And you tell them, okay, come to my firm, you can, but you're lying to them because there are no cases anymore to try. They aren't going to get trial skills. With 1% of the cases going to trial, you're not going to get trial skills. So then it occurred to me that what I ought to do is get involved in trying to study the Seventh Amendment and resuscitate it. So I became active with a vote. I was co-chair of the Save Our Juries Committee. And then I realized, well, bar associations just do so much because they're just lawyers like me who get together 3 times a year at a nice place, and they talk about it, and the next 4 months they do nothing because there's no consistent effort. So I figured out, what I got to do is set up a center like the Brennan Center at NYU. So it's at NYU Law School, the Jury Project. I'm doing it with my own funds, and it's an experiment. I've committed to fund it for 4 years. And it's going to be a civil jury project. And we will study things like, and hopefully with representatives of both the defense bar and the plaintiffs bar equally, because I believe nothing will be accomplished. And this right to a jury trial, by the way, is nothing that's on the right or the left. There's many people who are in the Tea Party who are passionate about jury trials, as there are people on the left who are passionate about them. So it's to get allies on both sides and to get a bipartisan group to study, is the Seventh Amendment worth protecting? Is it worth keeping jury trials? What can we do to remove the most obvious objections, like a better informed jury, better way of selecting juries, better way of communicating with jurors, better way of jurors deliberating, et cetera, to restore the faith of the public in jury trials. There's a public relations part, obviously, because most of the public, if you ask the general guy on the street, do you know jury trials are vanishing? They say, what do you mean?
Yeah.
They don't understand it. Because only 7% even realize that they have an arbitration clause that has waived a jury trial in the contracts they sign. So you've got to inform them that we're losing the right, and then you've got to inform the bar that there is, it's worth preserving, study it at least. And then I'm going to teach a law school course, but it's going to be how do you try a case to a jury in a way that removes the most common objections to trial by jury. It's too long, it's too expensive, it's too incomprehensible. How can we as lawyers and judges work together to try to preserve this precious constitutional right that we have? I mean, I don't think any citizen would be happy to, the average person does not want to lose any constitutional rights they have, whether it be jury trials or guns. And so that's what I'm going to be doing. I'm going to continue practicing law, but I've committed to teach this course and work at this on this project at NYU.
Well, great. So we're out of time, everyone. And again, this is the 25th in our webinar series of the new IP business models, and we'll continue on. Big focus, of course, now is the April 23rd conference, where we will bring many of these topics together in a synthesized, curated way. Again, we urge you to attend the conference in Palo Alto at the Sheraton on the 23rd. I want to thank Steve for your first webinar, Ray for your second. Karen and I are continuing on with this project. We want to thank Thomson Reuters West. And finally, Ray, thank you for bringing your book.
That's for Steve.
Go for it. By
he'll take
Raymond
the
P.
book.
Meyer.
I don't know if he wants to.
And we're leaving you from the Northern District of Texas. It's March of 2015. Thank you very much.
Thank you. Thank you.